right. All right. One more button, and I think we are good to go. Record to the cloud. All right. And we are live. Thanks for bearing with us, and good morning, everyone. Welcome back to another NGSBA webinar. My name is Michael Quedal, Quality Controls for the New Jersey School Boards Association. And thank you so much for joining us today as we talk about today's webinar, What's Brewing in Education Law? Coffee Talk with Kathy and Caitlin. Join us this morning for another new episode of this popular webinar series. Members of the NGSBA legal team will provide a timely overview of the most recent legal decisions posted by the Commissioner of Education and the School Ethics Commission concerning education law. If you're interested in learning more about the latest developments in education law, grab a cup of coffee and join us this morning as we informally discuss the facts from the most relevant cases, the determinations rendered, and how those decisions may implicate the service of board members and or administrators. I want to let everyone know that this webinar, as always, does offer one Board Member Academy credit for all of those here live in the room and stay for the duration of the presentation. You will be receiving one BMA credit. Just give us a couple days to have that reflected on your transcript due to it being a manual process on our end. But thank you so much for joining us live here in the room this morning. We appreciate you all. A couple things regarding the Zoom features really quickly. Towards the right side of your buttons, you will see the CC button. That's your closed captioning functionality. If you click that, it'll allow you to view the closed captioning of this session. You'll also be able to view and save the entire transcript of the session if you need it. Attendees of this webinar should be aware that the views expressed by non-NGSBA employees and outside speakers or panels are intended purely for informational purposes and do not necessarily represent the views, opinions, or mission of the New Jersey School Boards Association. NGSBA remains committed to providing nonpartisan and apolitical information, resources, and advocacy to advance public education and promote the achievement of all students through effective governance. Finally, today's session is being recorded and will be available through NGSBA's Sugo website. So the recording will be posted on the conference website. We encourage you all to view and share the recording with your district team and administration. So without further ado, it is now my pleasure to introduce Kathy Whalen, Legal Director, and Caitlin Pletcher, Legal Counsel for the New Jersey School Boards Association. Good morning to you both.
Good morning, Michael. Thank you, as always, for that great introduction. And good morning to all of you who have taken time out of your busy morning to attend today's webinar. Just as a reminder, for those who don't know me, my name is Kathy Whalen, and I am the Director of Legal. And with me here today is Caitlin Pletcher, who serves as Legal Counsel. We hope that everyone is off to a great school year. This is our last webinar series before workshop. Hopefully, everyone has signed up, and we look forward to seeing you at workshop. Today's webinar is going to cover decisions from the months of June and July for both the Commissioner of Education and for the School Ethics Commission. And with that, Caitlin is going to go over our disclaimer.
So good morning, everybody. And as always, the content of this webinar is for informational purposes only. It is not legal advice. Anything that we say today or by attending, it is not creating an attorney-client relationship with me and Kathy or anybody at New Jersey School Boards Association. And if you have any specific questions, even if you think it might be answered by one of the slides, please always consult with your board attorney on specific scenarios for formal legal advice.
All right. Thanks, Caitlin. So we're going to start with Commissioner of Education decisions from the month of June, starting with YH and SH on behalf of AH involving the Board of Ed of the Township of West Orange. So review of the facts. So after the superintendent issued a letter advising that AH had committed an act of HIB, the petitioners requested a hearing before the board. Despite that request, the board held a meeting and affirmed the superintendent's HIB determination. Importantly, the petitioners did not appear at the board's meeting, nor were they afforded a hearing before the board affirmed the superintendent's determination. Following the filing of a petition of appeal, the board conceded that it did not hold a hearing and requested that the matter be remanded so that it could conduct the hearing that it didn't yet conduct. Petitioners opposed that request for remand, They sought a reversal of the board's HIB determination, and they sought expungement of the HIB matter from H's student record. Just for clarity here, this is a procedural case. We're not going to get into the substance of the HIB because that is something which maybe we will see in a future decision, but that's not what this is about. This is a procedural case. So the administrative law judge granted the board's request for remand. In granting the request, the administrative law judge distinguished the present case from that was cited by petitioners, which was Sadlock v. Board of Ed of the Township of Cedar Grove. In that case, the ALJ concluded, as here, that the board failed to adhere to the procedural requirements under the ABR, or the Anti-Bullying Bill of Rights Act. However, remand was not appropriate because the state of the record and the board's lack of determination would not allow it to determine whether an act of HIB occurred. So that was in the Sadlock matter, and that's how this case is different, which is what the next slide says. So in this case, and unlike in Sadlock, there was no lack of documentation or an inability of the board to reach determination about whether AH had committed an act of HIB, because an executive summary of the incident contained specific statements made by AH, explained why those statements constituted HIB, and mentioned that there were student witnesses who had heard AH make the statements in question. Because there was ample information in the record to decide the HIB charge, and because petitioners did not receive a hearing before the board as they had requested, the ALJ determined that the appropriate remedy was a remand back to the board. So the Commissioner of Education stated that even though the board failed to comply with the procedural requirements of the ABR, the Commissioner did concur with the ALJ that given that there was enough information in the record from which the board could make a determination that remand was the appropriate remedy in this case. If the board affirmed that determination, the Commissioner noted that petitioners could then file another petition of appeal to challenge that underlying finding of a violation. So just some quick takeaways from this case. If a petition of appeal is filed before a board conducts a hearing, assuming one is requested, the matter can be remanded provided there is enough information in the record from which the board could make a determination about that underlying HIB charge. If there was insufficient information or an insufficient record, then an appropriate remedy could be to vacate that finding.
All right. Here is our next case, Khan versus the Board of Education of Ramapo Indian Hills. In this matter, the petitioner applied for a substitute teaching position in the district, and the superintendent recommended her to the board for this position. However, prior to the board's vote on her appointment, members of the public expressed concern about the hiring of this petitioner, and the board tabled the vote. At the next meeting, the vote was up on the agenda again, and the required number of votes were not there for her to be appointed, and she was not hired. So petitioner filed a petition of appeal claiming that by not hiring her, the board violated the First and 14th Amendments of the Constitution, U.S. and New Jersey, and the New Jersey Civil Rights Act by relying upon her social media posts regarding the board's operations to deny her employment in the district. So the administrative law judge dismissed all of her claims and granted the board's motion for summary decision. The judge explained that the petitioner was not employed by the board, and therefore she was not entitled to the protections related to the non-renewal of school district employees. And the board did not take any action to prevent her free expression, noting that this petitioner has to recognize that the use of free speech may result in consequences. And a public body is permitted to determine that the employment of a gadfly or opinionated individual does not necessarily support its objectives. So in other words, they had the discretion to take that into account and not to hire. The judge also noted that the petitioner did not demonstrate that the board's action was a result of a discriminatory action based upon a protected class, and she didn't present facts that would lead to a reasonable inference that her online activity formed the basis for the board's decision. So nothing was available that, but for those social media posts, they would have appointed her. The Commissioner of Education agreed with the administrative law judge's legal conclusion that the petitioner did not demonstrate that the board violated her constitutional rights. However, the commissioner did remand the matter back to the Office of Administrative Law for further fact-finding regarding the reasons why the board rejected the superintendent's recommendation to appoint the petitioner. And the commissioner noted that although a Board of Education has wide latitude regarding its employment decisions, the absence of any explanation whatsoever for its action here, it created a genuine issue of fact as to whether the board's reason was sufficient to preclude a summary decision at this stage. So ultimately, the board's decision may get, upheld, but here it just wasn't appropriate for summary decision yet without further information. So what this case reminds us of is that standard for personnel decisions is that the board cannot withhold its approval of the superintendent's recommendation for arbitrary and capricious reasons. And for purposes of a motion for summary decision where the matter would be dismissed without a hearing, there being no explanation at all as to why the board did not follow the superintendent's recommendation could have the petitioner's claim survive that motion for summary decision.
All right. Thank you. My apologies for all the coughing and the muting, but my children have gotten me sick. Okay, our next case. So in this case, petitioner was employed by the district for over 20 years, and his current position was assistant business administrator / board secretary. On November 25th, the superintendent suspended petitioner with pay, which is an important fact, noting in the suspension letter that his conduct was unprofessional, insubordinate, profane, and threatening. Petitioner filed a motion for emergent relief seeking reinstatement to his position, and the board filed a motion to dismiss. So this, again, is a procedural matter. What we have here is a decision concerning the decision to place this particular employee on leave or to be suspended, but with pay, not necessarily the underlying basis for that decision to suspend him. So the administrative law judge denied petitioner's request for emergent relief. And again, that request for relief was to be actually reinstated to his position. Because the petitioner must prove each of the 4 elements set forth in Crow v. DeGioia, the judge concluded the analysis, meaning stopped, after determining only one prong, which was the irreparable harm prong. There are 4 prongs, but you have to satisfy all 4. And in this case, the judge stopped after prong 1. And he did so because petitioner's argument that the mere fact of the suspension caused irreparable harm because he was receiving full pay and benefits was rejected. So the judge did not find that to be irreparable harm because he was, in fact, receiving his full pay, and merely being suspended was not enough to constitute irreparable harm. The judge also rejected petitioner's reliance on Sanchez v. City of Camden because that case involved a principal who was demoted, not suspended for cause, as was the case in this case. The Commissioner of Education concurred with the ALJ that petitioner failed to demonstrate entitlement to emergent relief and adopted the recommended order, which was denying petitioner's application for emergent relief, again, seeking reinstatement to that position. So absent any other facts, the mere status of a suspension in and of itself is not going to constitute irreparable harm within the meaning of the case law, which would then allow someone to be reinstated to their position.
All right, and we have another emergent application in this matter. And I always think, because we're discussing the June and July cases, I always think of June as really like emergent application season because of proms and graduations, etc. So we do tend to see more emergent applications at this time of year. So this is EB on behalf of AB versus the Board of Education of the Township of Hainesport. In this matter, a teacher observed 3 fourth grade students, including AB, ingest an unknown substance. And when questioned, the students refused to say what the substance was. So because the district didn't know what it was, they went into emergency measures. They did a shelter in place until paramedics arrived. And eventually the student who brought the substance to school, who was not AB, shared that the substance was a laundry cleaning product. AB claims that he only licked the substance, but he did not ingest it. Due to AB's involvement, though, in this incident, the district did suspend him for 2 days and banned him from attending the class trip to the Franklin Institute on May 30th. The petitioner filed a request for emergent relief, arguing that the disciplinary consequences were excessive because he did not bring the substance to school and he only licked it. The administrative law judge, again, it comes down to those Crow standards, which you have to satisfy all four of them. And because they were not satisfied, the request for emergent relief was denied, and the board was permitted to exclude the student from the field trip. The parent did make some creative arguments in arguing that there was irreparable harm, although all rejected by the judge. It's worth noting just to show that even with all of this, it still doesn't meet irreparable harm. So the parent explained that the child had looked forward to this field trip all year. There were exhibits at the Franklin Institute that would be permanently closing and that he may never be able to see. Some of his class assignments had been centered on the exhibits at the Franklin Institute, so he would miss the opportunity to connect the exhibits with the work that he had done in school. And it would also be emotional because his twin sister and classmates would be on the field trip. Again, all rejected as not being irreparable harm. As for the settled legal right, boards are, responsible for protecting the health, safety, and welfare of students. So they have the authority to establish rules of conduct and then to impose them to enforce the rules. Because they have that settled legal right, the petitioner did not have a likelihood of success on the merits, and there was not any evidence showing that the board's decision with respect to the discipline was arbitrary, capricious, or unreasonable. And finally, with balancing the equities, the board has the obligation to all students. So, the judge explained that the petitioner's arguments failed to recognize that the child's actions had a negative impact on other students. There was a shelter in place. It definitely did disrupt the school day. So therefore, based on all of that, the request for emergent relief was denied. And the Commissioner of Education agreed and adopted the recommended order denying the application for emergent relief. So just shows that even when there are some things that may be unique to, say, a field trip, it still is most likely not enough to satisfy an emergent relief application.
So what's more fun than another request for emergent relief, which is the next case, which is AA v. Board of Ed of the Freehold Regional High School District. So in this case, in early June, AA brought an 8.5-inch folding knife to school in violation of the district's policies, regulation, and student code of conduct. Because AA had been diagnosed with attention deficit hyperactivity disorder, the district conducted a manifestation determination meeting, but concluded that his behavior was not a manifestation of his disability. For this incident, and because AA had previously received a 10-day out-of-school suspension for bringing a weapon to school, the district placed AA on a 10-day out-of-school suspension, followed by 45 days of home instruction, and also prohibited him from participating in his high school graduation. AA filed a petition of appeal and an emergent relief application to challenge the district's decision to exclude him from his high school graduation. And as we've seen in the last few cases, the administrative law judge found that because AA did not satisfy the factors set forth in Crow v. DeGioia, the request for emergent relief was denied. So in terms of the irreparable harm argument that was made, although there is no adequate after-the-fact remedy that can adequately address the intangibles of losing an experience like a graduation, the real issue in this case was whether petitioner was entitled to participate in the graduation ceremony. And because petitioner did not have a likelihood of success on the merits, he had failed to establish irreparable harm. In terms of the settled legal right, under the district's regulations and student discipline policy, including that code of conduct, the board clearly has the authority to deny participation in extracurricular activities, including graduation. Again, on the likelihood of success on the merits, based on that evidence, the board's decision to exclude AA from graduation was within its discretion, and there was not enough objective evidence in the record to conclude that that decision was arbitrary, capricious, without a rational basis, or was induced by improper motives. And balancing the equities is probably, the hardest one that pulls at all of our hearts as parents, to have your student lose the opportunity to participate in graduation. But AA failed to show that when the equities and interests of the parties were balanced, AA would suffer greater harm than the board would suffer if the requested relief was not granted. While AA and his family have a personal stake in seeing AA participate in the graduation ceremony, the district also had a very important interest in seeing that its disciplinary policies are enforced. Therefore, that request for emergent relief was denied, and the Commissioner of Education concurred with the ALJ that the denial of the request for emergent relief was appropriate. And this case, as Caitlin mentioned before, like we see often in May and June when there are decisions made by boards of education to refuse participation in graduation ceremonies or even field trips, these things are privileges. They are not rights.
All right, our next three cases, we consolidated them all together because they're very similar facts. They all involve the same petitioner, Milk Ridge, which is a law firm, and they all involve the indemnification of board employees and that request for reimbursement of counsel fees. So I'm going to go over the facts generally and then just give a little bit of a reminder about indemnification and then give you some takeaways. So in all of these matters, the NJEA had appointed this law firm, the petitioner, as legal counsel to employees of the board who were investigated by the New Jersey Department of Children and Families, the Institutional Abuse Investigation Unit, IAIU. So for these investigations, there's a very rapid timeline. The investigation has to be initiated within 24 hours of the report, and the entire investigation has to be completed within 60 days. So in light of this very rapid timeline, this petition, the law firm did not seek indemnification of its legal fees and costs from the three different boards of education until after the conclusion of the IAIU's investigations. So what does the statute say about indemnification of employees and board members? Whenever any civil or administrative action or other legal proceeding has been or shall be brought against any person holding any office, position, or employment under the jurisdiction of any board of education for any act or omission arising out of and in the course of the performance of the duties of such office, position, and employment, the board shall defray all costs of defending such action. So we've got that whenever this action is brought. So what are the obligations of the board member or employee whenever this happens? And we learn from a recent New Jersey Appellate Division case in 2023, Azaro versus the Board of Education of the City of Trenton, that in civil and administrative matters, a person seeking reimbursement pursuant to 18A 16-6, the person cannot wait until the action is completed and must provide the school board with reasonable notice after the initiation of the proceeding. So we've got that reasonable notice standard. And in all three of the Milk Ridge matters, the administrative law judge denied the request for reimbursement of counsel fees and costs because of their failure to provide this reasonable notice of the request to the boards of education. And what some of the takeaways from this case are regarding reasonable notice. One, even though these cases were all proceeded very quickly and the average time of representation for these employees by that law firm was 40 days. So the judge explained that even if you don't think you'll hear back from the board, they may not give you an answer about indemnification. That doesn't matter. Your obligation is to provide that notice. And they might say, no, you can sort that out all later and challenge their decision later, but you need to provide that notice. And for these cases with this quick turnaround, the judge said that under these circumstances, reasonable notice would have been immediate notice. The Commissioner of Education did not necessarily say yes or no to that, but did remind the parties that this reasonable notice standard is very fact sensitive. So it can be different depending on whatever the case is. Here, because of the quick turnaround, the judge said immediate. We also learned that one of the arguments made by the Board of Education was that these IAAU investigations were not any kind of action that would be covered for purposes of indemnification, but the judge said, yes, they are. They're considered an administrative action, so they would be included. And finally, the other argument one of the boards made was that the conduct was not in the course of the employee's duty, so there also should be no indemnification because of that. And the judge said, no, in these kinds of matters where the the investigation results in, an unfounded, that there was no wrongdoing and there's nothing else in the record to suggest wrongdoing, we're going to assume that the employee was acting within the course of duty for purposes of indemnification. Again, because reasonable notice was not provided, the indemnification was denied in all of the matters. But those are just some takeaways from the 3 cases.
So if you're a board member and you're listening to this case and you're wondering, well, what does this mean for me? It means if someone submits a request for indemnification to the board, it doesn't necessarily mean automatically that the board is going to be responsible to indemnify the employee in connection with that proceeding. There's going to have to be some threshold determinations in terms of whether that reasonable notice was provided. And as Caitlin said, it's extremely fact sensitive. And what we learned from this case is in IAIU investigations, that timeline is immediate, right? It's not something that you can wait in order to receive indemnification for. You have to provide that notice right away. Excuse me. So that's just something for board members to keep in mind when these requests come in, that there is a little bit of latitude that's afforded here. And the board doesn't have to give the requesting party an answer right away, because there could be a reason, and in most instances there will be a reason why you need to consult with your board attorney to figure out whether or not there is in fact an obligation to indemnify the employee in that circumstance. Mm-hmm. All right, so moving on, there were a couple of other Commissioner of Education decisions that were decided in the month of June that we thought were worthy of note, but not necessarily multiple slides, just that we thought were interesting. So we're just going to go over those real quickly. So the first one is Baldessaro v. Board of Ed of the Township of Washington. And in that case, the commissioner concurred with the ALJ that Baldessaro, again, this entitlement to emergent relief is popping in June, that he was not entitled to it, and that dismissal was appropriate because he, as a resident and taxpayer, lacked standing to pursue his claim. So this is a standing case. So not necessarily everything that is filed against the board is actionable within the meaning of the education law. It's just an interesting FYI. And in JCMC on behalf of MC and the Board of Ed of the Township of Randolph, compensatory education and tuition reimbursement are not available remedies under the Strengthening Gifted and Talented Education Act. The only available remedies under that act are administrative, which are the right to file a complaint against the board for noncompliance and the right to appeal the board's resulting decision to the commissioner. We're going to move on to July decisions, and Caitlin's back up.
So CH on behalf of PH versus the Board of Ed of the Town of Secaucus. In this matter, PH, who was an almost 12-year-old 7th grade student, called a male student a midget and a Jewish monkey during physical education class. During the investigation, she admitted that she was annoyed by the student singing and dancing during physical education class. She was having a bad day, and she lashed out at him. She also admitted that she made a mistake and wrote an apology email to the victim. Following the investigation and a board hearing, the board affirmed the anti-bullying specialist finding that PH did commit an act of HIV. Petitioner appealed the determination and argued that the board made a litany of administrative and factual errors during the investigation. The administrative law judge found that the petitioner did not provide any evidence to support the claim that PH did not commit an act of HIV, and certainly no logical narrative supporting that position. And the judge, we see this a lot with HIV matters, that intent is not relevant. A reasonable person here could very easily conclude that her motivation in both calling AV a Jewish monkey and a midget was motivated by an actual or perceived characteristic. So it doesn't matter that she was having a bad day, doesn't matter if she didn't mean it, intent is not relevant. And here, the only evidence supplied supports the conclusion that the event substantially disrupted or interfered with the operation of the school or the rights of other students. AV that day went to see the guidance counselor twice, and then the mother reported the next day. And regardless, again, of the intent, the conduct had the effect of insulting or demeaning AV. And it did create a hostile educational environment by interfering with his education, to the degree that he expressed a desire to change classes to avoid PH, to not attend school and also to be homeschooled. So, based on all of the above, the petitioner did not demonstrate that the board's determination was arbitrary, capricious, or unreasonable. As for the alleged procedural violations, there was nothing about those actions that substantially impacted the case. So it did not, even if there were some procedural violations, they were so minor and did not affect anything that they were not, did not change the outcome. The petitioners were afforded a full and fair opportunity to defend against the HIB allegations. And again, no substantive impact on the case, so there was no reason to reverse the board's decision. Commissioner of Education concurs that the board did not act arbitrarily or capriciously in determining that PH committed an act of HIB, and also agrees that the alleged administrative errors had no substantive impact on the case that would warrant a reversal of the board's decision.
All right. So again, there were not that many decisions in July, since we just did them in one slide, that were worthy of note. But there was just one other, because there are so many School Ethics Commission decisions that we're going to discuss. So just quickly, for the month of July, there's only one case where the commissioner concurred with the administrative law judge that petitioner, this is again a standing case, lacks standing to pursue their due process claims on behalf of the superintendent, and that they did not qualify as interested persons. An interesting read, where you have a bunch of folks who are trying to make personnel challenges on behalf of the superintendent, but the commissioner agreed that they did not, simply because they are residents and taxpayers, have standing to assert those personnel claims on behalf of the superintendent. And with that, we're going to move to the School Ethics Commission and June decisions, which are, and we're going to go over our, as you'll see, there's a many violation cases in June and July, and there are a handful of no probable cause decisions, which we'll go over very summarily, because we want to take the time to really emphasize those cases where there were violations of the School Ethics Act found. So Caitlin's going to start us off with C-12522.
All right, violation number 1. So in this matter, prior to becoming a board member, the respondent co-founded and co-led the district's Special Education Parental Advisory Group, CPAG. And while a board member, she continued to hold her CPAG leadership role and also served as the chair of the board's Special Education Committee. So as the Special Education Committee chairperson, she was a liaison between the board and the district Special Education Department. So the incident that led to this complaint and ultimately a violation, she sent an email from her board email account to the CPAG members, informing them that she intended to attend the upcoming board meeting as a co-leader of CPAG and not as a board member. So the administrative law judge granted the complainant's motion for summary decision, finding that means without a hearing, just on the papers, that the respondent violated 18A 12-24D and recommended a penalty of reprimand. And this violation was based on the use of her official board email account to send a message to the CPAG members about attending the board meeting. And the administrative law judge specifically focused on that email, finding that the use of her board email account to CPAG was troublesome. And the judge also noted that although respondent is permitted to be a member of CPAG as a parent and a board member, she failed to be vigilant in her maintaining appropriate boundaries and therefore violated the School Ethics Act. And just to go into, CPAG membership, they said it's similar to membership in the PTA or a special education parent discussion group, cited some previous and advisory opinions from the School Ethics Commission. So dual membership in CPAG and the board is not per se, a conflict, and would not reasonably be expected to prejudice respondent's independence of judgment in the exercise of her official duties as a board member. However, in this matter, respondent blurred the line between her role as a board member and co-leader of CPAG by advocating on behalf of special education students and their families. Because this was her first violation, the judge recommended a penalty of reprimand, which is the least serious penalty. The School Ethics Commission adopted the findings of facts and the legal conclusion that she violated Section 24D and also the recommended penalty of reprimand. And the School Ethics Commission also agreed that being a member of CPAG is not a per se conflict. However, by sending that email from her board email account to CPAG members, she created a justifiable impression that objectivity or independence had been impaired. And they also agreed about the reprimand because although it was inappropriate and she did compromise the board with her email, it was not ongoing conduct. The administrative law judge had only found one correspondence when respondent used her board email. And then the commissioner, this next goes to Commissioner of Education regarding the penalty, and the commissioner also agreed that the penalty of reprimand was appropriate under the circumstances.
All right, so that was the only violation case from the month of June. I promise there's a lot more in July. But there were a number of cases that were dismissed for not having probable cause. So they're listed here. There are 5 cases. And to give you, some keywords about what those cases are about, if you have interest in reviewing them for the basis for the dismissal of those cases, they are set forth for you on the slide. As always, we will provide you with a slide deck. It will be available to everyone who is in attendance. And there are links to these decisions if you would like to read any more of them in detail. The reason we're not going over them in too much detail, as I said before, is because there are so many violation cases, and also because there's not a lot of information in these decisions as to why there was no probable cause, only that the facts and circumstances presented were not enough to establish a violation, but no real explanation as to the why, just that it was not. So feel free to read those if you have any interest in those topics. And now we'll go to July.
Back to the violations. All right, C-2418. All right, in this matter, while his daughter-in-law was employed in the district, responded in his capacity as board president, appointed other non-conflicted members to serve on the board's personnel committee. However, during a personnel committee meeting, he raised a carryover item from the previous year, which was the superintendent's contract status. He was present for the entire meeting, which lasted about 15-20 minutes. And following the meeting, he asked board counsel to issue a rice notice to the superintendent so his performance could be discussed. A few months later, the respondent again asked board counsel to issue a rice notice to the superintendent so a different matter related to his employment could be discussed. Complaint was filed alleging multiple violations of the School Ethics Act, and only a few that are listed here were transmitted to the Office of Administrative Law. The administrative law judge found that the respondent violated sections B, C, and 24.1A and recommended a penalty of reprimand. The judge noted that respondent admitted that he discussed the superintendent's present and future employment with the board, and he also told the board to issue a rice notice on more than one occasion. So these actions took place at a time when he knew he had a conflict with regard to the superintendent because of his daughter-in-law's employment in the district. For Section 24B, the violation was based on his involvement in the personnel committee discussion and the directive to issue a rice notice to the superintendent. For 24C, in accordance with the previous advisory caution from the School Ethics Commission, board members should not, with relatives employed in the same district, should not even be in the same room when the board discusses matters that affect the employment of the relative's supervisor, and therefore there was a violation of that section. And as for 24.1A, because respondent admitted that he knew he was conflicted from matters related to the superintendent because of his daughter-in-law's employment, he nevertheless disregarded the conflict by participating in discussions related to the contract of the individual who has supervisory authority over his daughter-in-law, and therefore there was a violation of that section as well. There are other notable findings from the decision. Even though respondent chose 4 non-conflicted board members to serve on the personnel committee, so acknowledging that, the non-conflicted members should be the ones to serve, he seemed to have missed the obvious, which is that he should not have played a role in selecting the committee. And because the superintendent could take a variety of managerial actions or decisions which could affect his daughter-in-law's employment, it is almost obvious that respondent should have avoided any decision-making discussions regarding the superintendent. School Ethics Commission adopts the administrative law judge's findings of facts and the legal conclusions that respondent violated sections B and C. However, they rejected the legal conclusion that respondent violated section 24.1A, and they also modified the penalty from reprimand to censure to make it more serious. And they disagreed with the violation of 24.1A because, and it's related to, we've talked about this a bunch of times in our webinars, what proofs are needed to prove that violation. And you need to provide a copy of a final decision from any court of law or administrative agency demonstrating that respondent acted unethically or illegally. So if there's no court order, you don't have the required proofs. With respect to the penalty, the School Ethics Commission explained that they made it more serious to censure because it has already issued several advisory opinions which clearly state that the acts committed by the respondent would violate sections B and C of the School Ethics Act. He was aware of this and admitted to his daughter-in-law's employment in the district and the conflicts that arise from that employment. And he also was in a leadership position as board president on the board. So just, can't emphasize enough, if you have a relative or an immediate family member who is employed in the district, you cannot touch anything related to the superintendent at all. It's not just the votes on the contract or the evaluation, it's any discussions. The conflict includes anything at all related to the superintendent.
All right, our next one is C7521 and 3722, which is consolidated. So prior to her election to the board, respondent was an active member of the community and was at times at odds with the then existing board and administration. Respondent was also the administrator of a Facebook page entitled Monroe Township Watchdog and Unity in Community, where she and other community members would post things related to the board. Following her election, complainants alleged that the respondent posted comments and information on the same social media account without a disclaimer, and that her comments and posts violated 24B, 24.1E, and 24.1F. The administrative law judge in this case found that the respondent did violate all of those cited provisions of the School Ethics Act, and according to the administrative law judge, respondent's posts had a clear nexus to the board and were directly relevant to board matters or business. Many posts did not include a disclaimer, and while some posts did, they were still directly related to board matters or related to matters that respondent had specific knowledge about because of her position on the board. Therefore, the ALJ found that the respondent violated 24B, 24.1E, and 24.1F, and the ALJ recommended a penalty of reprimand, and I somehow skipped forward 3 times. My apologies. There we go. So the SEC adopted the ALJ's findings of fact and also adopted the conclusions that there were the violations of the School Ethics Act that were cited. In adopting those legal conclusions, the SEC found that there was, just as the ALJ had determined, a sufficient nexus between respondent's social media posts and her board membership, and given the context of those posts, a reasonable member of the public could perceive that she was speaking in her official capacity or pursuant to her official duties. Although respondent's posts compromised the board, the SEC agreed with the ALJ that reprimand was appropriate because it was the respondent's first adjudicated violation of the School Ethics Act.
All right.
So just real quickly, we can never caution enough about social media. You have to be careful about the accounts that you're using and about the subjects that you're posting about. All right. Sorry, Caitlin, your turn.
No. Another consolidated matter. We've got C4322, C4422, C5422, and C6222. So this matter, and there's a lot going on, so bear with me here. The facts that are involved are as such. In July 2021, a retired teacher and respondent who was also the board president at the time, were engaged in a personal email communication about the upcoming board election. In this communication, the respondent / board president expressed her personal opinion about many of the candidates and also identified whom she supported and why. Respondent also indicated whom she believed should be the district's next superintendent. So we're going to call that part of this matter the email. In December 2021, a new board member sent a text message to respondent discussing her disagreement with a decision to grant tenure to a building principal. Respondent replied that she would not engage in such discussions about employees via text or in writing. That part we'll call the text message. In February of 2022, a small committee of board members, including the respondent, began the process of finding a new superintendent. On March 22nd, the retired teacher read a portion of that email between he and respondent at a public board meeting. 2 days later, respondent recused herself from the superintendent search and later resigned as board president, but remained on the board. On April 26th, the respondent read the text message that the new board member had sent to her. And this was at a board meeting. Although the respondent did not disclose the name of the district staff member that was named in the text message, she disclosed his position, his salary, and his marriage to a part-time teacher in the district. So still gave a lot of context clues as to who that employee was, and again, read that at a board meeting. In May 2022, respondent resigned from the board. Respondent applied for a position with the company, and she contacted the CEO, identifying herself as a board member, and wanted to know whether her application was jeopardized by the actions or the opinions of one of the named complainants. And that is the section we'll call the application. So there was 4 complaints filed, all consolidated, contending that respondent violated multiple provisions of the School Ethics Act in connection with the email, the text message, and the application. The administrative law judge found that respondent to action in reading the text message from a fellow board member at a board meeting violated sections 24.1E, 24.1G, and 24.1I. It violated 24.1E according to the judge because the decision to disclose the contents of another board member's private text message at a public board meeting was clearly outside the scope of her duties as a board member. As for 24.1G, her disclosure of another board member's opinion, regardless of its accuracy, had the potential to discredit the administration and harm the reputation of the board and the staff member involved. And as for 24.1I, the statement attributed to another board member by the respondent undermined the superintendent and compromised the reputation of the building principal, even though he was not specifically named. The administrative law judge found that there was no violations, though, with respect to the email or the application. As it related to the email, there was no evidence that respondent made any promises, took any affirmative action, or otherwise tried to influence other board members to hire whom she believed was the best candidate. And as for the application, there was no evidence to suggest that the CEO believed that respondent had contacted her in her official capacity as a board member, or that respondent was speaking on behalf of the board during their telephone conversation. So based on the violations related to the text message, the ALJ recommended a penalty of reprimand. We get to the School Ethics Commission, who adopts the ALJ's findings of fact, adopts the legal conclusions that respondent did not violate 24.1B, 24.1E, or 24.1F, adopted the legal conclusions that she did violate 24.1E, 24.1G, or 24.1I, and adopted the conclusion that she did not violate 24.1E, and also adopted the recommended penalty of reprimand.
So a nicer, less wordy way to say that, despite the slide, is that agreed that the text message was a violation and that the incident at the application, reading the text message at the board meeting was the violation, and everything else was not.
Everything
so the
else.
Email and the application were not.
Yes. Thank you. That was much easier to understand.
Hey, that's what it said. Okay. C-7423. So respondent used his personal social media account to respond to a social media post made by an anonymous member of the social media group entitled Parents and Taxpayers of the cited school district, Putting Kids First, and respondent is also a member. The post and the ensuing comments concern generally the potential banning of books in schools. Members of the public then reacted to respondent's post and asked for a clarification and his thoughts on banning books. Although respondent did not directly reference the board in his comments, it was clear from the continuing string of comments that respondent's social media posts were being interpreted as discussing his role as a board member and the impending business and planned actions of the board as it related to book banning. At no point during the social media discussion did respondent post a disclaimer that he was speaking in his personal capacity and not as a member of the board. So after an ethics complaint was filed, an administrative law judge found that respondent violated 24.1E. According to the ALJ, respondent's posts were reasonably interpreted as being made in his capacity as a board member, and public commentary on prospective, albeit unspecified, board business regarding books and the banning of books in the school system clearly related to his role and service as a board member. Nonetheless, oh, did I say he established? I meant to say failed to establish that this was a violation of 24.1E. But even though the posts were reasonably interpreted as being made in an official capacity, the complainant failed to present any factual evidence to support a finding that the post had the potential to compromise the board. So just for clarity, because I'm confusing you to unconfuse you in a minute, the ALJ says there is no violation of 24.1E, says that the posts are offered in an official capacity, but says that there is not enough information or evidence to show that the board was compromised. And the reason I confused myself is because the SEC is going to turn this decision on its head. So the SEC adopts the factual findings, meaning that the comments are offered in that official capacity, but modifies the legal conclusion to say that there was a violation of 24.1E. So the SEC agreed with the ALJ that there was definitely a sufficient nexus between the social media account, the post, and his service on the board, such that it was being offered in official capacity. And the SEC disagreed with the ALJ that complainant did not prove that the comments could compromise the board. So in other words, the SEC said those posts did compromise the board. As a result of respondent's social media posts, different district staff expressed concern about what was going to happen to material they were teaching in the classrooms. So in other words, things that were happening on social media came back into the district because of these comments on social media. While the actual issue of book banning might not have been before the board, the post was directly commenting on potential or future board activities, including activities or functions that could come before the board. Because they had the potential to compromise the board, the SEC found that the social media post did violate 24.1E, and the SEC recommended a penalty of reprimand for this one-time occurrence. And earlier this month, 2 weeks ago, the Commissioner of Education concurred with the penalty recommended by the SEC for respondents' actions in making those comments on social media.
All right, our last decisions, they are the no probable cause decisions from July. As Kathy mentioned earlier, these are just dismissals, but here are some key words from them in case you do want to read more about the topic. So we've got in C8024, it was related to a personal opinion, personal views. C8124 was untimely. So it talks about that 180-day limitation period that you have to file from the knowledge of an occurrence of alleged violation. Same in C8324 with also some social media and disclaimer allegations. And finally, C8624 related to personal opinion, personal views, and official capacity, but not in the official capacity was both determined.
All right, so here's our contact information. As always, if you have any questions, you can reach out to Caitlin or I. As I mentioned at the outset, we look forward to seeing everybody at workshop. Hopefully you'll be attending one of our governance trainings. If not, we'll be in the legal and labor and policy den if you want to stop by. But I'll turn it back over to you, Michael.
All right. Thank you both so much. Always a fabulous session. Thank you so much, Kathy and Caitlin. Thank you all for joining us live here in the room. We so appreciate you being here live with us and also your interest in our content. We have another webinar tomorrow. It's a technology webinar, so definitely sign up for that. It's visit us at ngsba.org. Under the trainings tab, click webinars, as you'll see tomorrow's webinar where you can register for. You also see all of our previous webinars that we've had, along with the webinar recordings as well. As Kathy stated in the beginning of the presentation, we will be uploading this slide deck to the SWUGO site, how everyone came in here this morning. So we encourage you to view that and share it within your district as a resource. Just want to reiterate again what Kathy said before. Workshop is just around the corner. Unbelievably, we are like under a month away. There is still time to register. If you haven't registered already, please contact your business administrator to register you as soon as possible. The group registration rate is $2,300 for up to 25 team members. So if you're already registered, make sure you fill out and maximize that badge registration. Bring your entire district team. Obviously, your full board, your superintendent, business administrator, IT director. We have a whole, we're partnering with technology folks around the state. So we have a full technology track. There's CEFM credits for facility directors. For the business administrators, we have QPA credits. So there's a ton of opportunities for your entire district team, curriculum directors, really everyone.
HR.
HR, yes. Kathy, you want to do a plug for what's going on for HR folks down there?
We're gonna be conducting the first annual PAA Day, which is the Personnel Administrators Association. That's where your district's HR related personnel are associate members, and we provide lots of great information about HR related topics to those staff members, and they are an incredible group of HR folks with various titles. So we're really looking forward to that program on Monday, which is only open to PAA members. So if you have an HR professional of whatever title, director of personnel, HR manager, whatever it may be, interested in attending, please have them sign up. We'd love to have them.
Yep. Please contact your business administrator and say, listen, we need to fill out this district registration because frankly, for $2,300 for 25 team members, it comes out to about $23 a day for Monday through Thursday. So it's a great value. We have 4 days of training. The exhibit floor is open on Tuesday and Wednesday of that week, the 21st and 22nd. We have a ton of great exhibitors and sponsors and sessions and keynotes. The commissioner will be there. So we're really, really pumped and we'd love to see everyone there. We're excited to see everyone there. I think that's it for us at this time. Again, please register for tomorrow's webinar. That's at 1 p.m. It's a technology webinar, so definitely register on our website, and we will see you very, very soon. I hope everyone has a great rest of your day, and yeah, talk to you soon. Thanks, everyone. Bye, Kathy. Bye, Caitlin.